Just wanted to do a quick video this morning around an issue that I'm seeing a lot lately. And it's something that we hear from a lot of prospective new clients, and that is that there is a domestic violence order in place that dictates parenting arrangements. For example, it might be the other party took a DV order out on me, and because of this, I can't see my kids at all. Now, I should note at the outset, when I refer to a DV order, I'm using this as a blanket term. Each state has different terminology for these orders. For example, a domestic violence order, an IVO, an AVO, etc. But they're all effectively the same thing. It's an order that protects a person, who's referred to as the aggrieved, from suffering domestic violence from the respondent, the other party, okay? Now, these orders will often name the children within the order of the person who needs protection. So they'll be named perhaps as children of the aggrieved. And so the order might say something like, the respondent is not to approach within 100 meters of the aggrieved or the named children. Now, from sort of a layperson perspective, obviously this can create issues in terms of having contact with the children. But it's important to note here that even though that order refers to the children, it's not a parenting order. Which can be made within the family jurisdiction and which deals with the actual arrangements for the children. And that's a really important distinction because sometimes the order that is made in the family jurisdiction might actually conflict with the terms of the domestic violence order. So the domestic violence order might say that the children can't be approached by one of the parents, but the order made in the family jurisdiction might allow for the children to spend time with both parents or live with both parents. Now, this is a really important part. Where there is that conflict, the order of the family jurisdiction wins out and it will override the domestic violence order to the extent that is necessary to resolve the conflict between the two of them. So, important point number one, I suppose, even if there is a domestic violence order in place that might seem to restrict a parent from being with their children or spending time with their children, that doesn't mean that that's that, and that nothing can occur or be done or that everybody just accepts that, okay? Because the family jurisdiction will ultimately have the power, if appropriate, to make orders that contradict that domestic violence order. The second important part is that domestic violence orders often include exceptions to allow children to spend time with their parents. For example, it might be something like the children aren't to be approached by the parent except for the purpose of spending time with that parent in accordance with an order of the court or a parenting plan or as agreed in writing between the parties. And lots of people miss that part. They see the general restriction on not spending time. They don't see that exception. Perhaps they don't comprehend it, or perhaps because of the emotion involved, they don't really see that part of it. And they just take the view, look, I can't see my kids because there's a domestic violence order in place. And that's not necessarily the case because there's that exception there. So the big takeaway, I suppose, is even if there is a domestic violence order in place, you should still be obtaining legal advice around what is most appropriate for the children and what should be done in terms of the time that they spend with each parent, because that domestic violence order does not determine things. The family court has the jurisdiction.